let's see. I'm going to be using here as a reference the Black's Law Dictionary. This is the sixth edition. So let's do this. Let's flip the camera here. And I've tried to read through my phone and have not been that successful. So I'm going to just try to place the camera and I'm going to read. Let's see. Here it says Antitrust Acts, right? Federal and state statutes to protect trade and commerce from unlawful restraints, price, discriminations, interesting, price fixing, and monopolies. This is interesting, and monopolies. Most states have many antitrust acts patterned on the federal acts. The principal federal antitrust acts are Sherman Act 1890. We got here Clayton Act 1914, Federal Trade Commission Act 1914, Robertson-Patman Act 1936. And it got some things here to reference to. It says C boycott, combination and restraint of trade, Hart-Scott, Rodino, Antitrust Improvement Act, per se violation, prefixing, restraints of trade, and some here I found interesting. Rule of reasoning. This is family. This is very interesting because this is setting a premise of how one is supposed to reason what monopoly is, what price fixing is, what discrimination is. So what me and you may think is monopolies to the system that Congress and the population that has the power to place these rules and regulation, they already established in there so it won't go way left or way right, how you are to apply what rules are to be context around the word monopoly, because I find that very interesting. I would even put an indictment to say that the NFL should be looked at for antitrust laws. A lot of the sports monopolies should be looked at for antitrust laws. Do you know back early in the segregation era, I would say, I can't recall a day, I want to say maybe early 1900s or so forth, there were Negro leagues, very successful Negro leagues, very successful Negro teams. And those teams were, to lack of a better word, they were destroyed. They were cut out. They were outbought. They were they weren't able to compete due to certain, I believe, price fixing, discriminations, and commerce restraints and so forth. That I believe that theirs is actually a claim of antitrust claims or laws that could maybe pursued against these monopolies, these sports monopolies. That's something to think about. That's my opinion, but have not been researched or in further depth. But something to think about. All right. So let's see here before we go looking at that what we call rule of reasoning. I want to go online and look a little bit further about the antitrust law. What is the antitrust law, right? And I'm going to flip my camera here. And what you're seeing here is, you can look this up. This is Investopedia. If I'm saying that right. And here is an article, Understanding Antitrust Laws, right? And I'm assuming if you break that word down, is really anti and then trust. So It has something to deal with trust, which we'll be looking at in a minute here. What is a trust, right? As well. Okay, here we go. It says many countries have broad laws that protect consumers and regulate how companies operate their business. The goal of these laws is to provide an equal playing field for similar businesses that operate in a specific industry while preventing them from gaining too much power over their competition. Simply put, they stop businesses from playing dirty in order to make a profit. These are called antitrust laws. And so my question for that is that what about black businesses? What about black businesses? How does this antitrust law apply to black businesses that have been unfairly wiped out due to Commerce Plan restraints? That's a question, family. Here it is. What are antitrust laws? Just read. Antitrust laws refer to competition laws, are statutes developed by the U.S. government to protect consumers from predatory business practices. They ensure that fair competition exists in an open market economy. These laws have evolved along with the market. Vigilante guarding against would-be monopolies and disruptions to the productive ebb and flow of competition. Man, so many flags are jumping out to me. Antitrust laws are applied to a wide range of questionable business activities, including but not limited to market allocation, bid rigging, price fixing, and monopolies. Below, we take a look at the activities these laws protect against. Something that come to mind too right off is my understanding that it was, I can't remember the case, but I remember hearing about some brothers and sisters who was in the beauty cosmetic businesses, like cosmetic hair products, wigs, weaves, and so forth, and was told that pretty much they could not gain a monopoly, or they couldn't get around the monopoly that I believe the Koreans or the Asians had on the market, because they could not compete with how they buy in groups, or they have these discounts to the resources. And therefore, since they could not get the product at a much lower price than the Koreans and the Asians that sell black American African, are y'all there? American African products, right? They was forced to close their doors because the profit margin they just couldn't compete with. This and that, or what I'm talking about, should be indictments for antitrust laws. It should be indictments for antitrust laws. Let's see what more can we learn about this. Who enforces these? That's what I want to know. I believe it's now the Florida Trade Commission. Let's jump down a little bit. It says here, in 2000, the Federal Trade Commission, FTC, found FMC Corp guilty of colluding with Ashaya commercial industry to divide the market for microcrystalline cellulose, a primary bidder in pharmaceutical tablets. Well, let me go back up. So I'm trying to get the piece. who actually prosecute these things. Let's see, antitrust laws are applied to why we read that if the laws didn't exist, consumers would not benefit from different options or competition in the market. Let's keep going. Market allocation. Suppose companies operate in the Northeast and your company does business in the Southwest. You agree to stay out of my territory. I won't enter yours. And because the costs of doing business are so high that startups have no chance of competing, we both have a de facto monopoly. That family. It's talking about bid rigging is illegal. There are 3 companies in the industry that's giving examples. Price fixing. Let's look at monopolies. Usually when most people hear the term antitrust, they think of monopolies. Monopolies refer to the dominance of an industry or a sector by one company or firm while cutting out the competition. Family, that sounds familiar. That sounds like a political system that we call today, that we call white supremacy, racism. One of the most well-known antitrust cases in recent memory involved Microsoft, which was found guilty of anti-competitive monopolizing actions by forcing its own web browsers upon computers that had installed the Windows operating system. Get out of here. Are you serious? I need y'all to, hey, on 1, 2, 3, I want you to say with me, are you serious? 1, 2, 3. Are you serious? Oh man. Microsoft. Come on. Let's see. I'm trying to see who. Let's take who oversees this. Let's see. Let's take a brief look at the main antitrust laws in the United States. The core of the United States legislation was created by 3 pieces of legislation. The Sherman Antitrust Act of 1890, which we're going to take a look at. The Federal Trade Commission Act, which was also created the FTC, and the Clayton Antitrust Act. Let's look at number 2 here for example. The Federal Trade Commission Act bans unfair methods of competition, and the Unfair Deception Acts or acts of practices. According to the Supreme Court, violations of the Sherman Antitrust Act also violated the Federal Trade Commission Act. Therefore, even though the FTC cannot technically enforce the Sherman Antitrust Act, it can bring cases under the FTC Act against violations of the Sherman Antitrust Act. It's a lot of wiggy-moggy going on there. But if you see here, it appears that the Federal Trade Commission is responsible or has the power to enforce the antitrust acts. I don't see that outright. It may be in here because I'm skipping around. But we got an idea, right, of the Antitrust Act. And since we show here that it starts with, where is it? The Sherman Antitrust Act. We're going to look at that, 1890. Let's look at that, and I have it here already pulled up. This is from ourdocuments.gov, right? And the Sherman, if you just type that in, you can find this. The Sherman Antitrust Act 1890. It says, let's see here. Let me read it. Let me get it where it'll be on my phone, but I'm going to read it without looking into my phone. The Sherman Antitrust Act of 1890 was first passed by the U.S. Congress to prohibit trusts. It was named after Senator John Sherman of Ohio. Interesting. Who was a chairman of the Senate Finance Committee and the Treasury and the Secretary of Treasury under President Hayes. That sounds like an antitrust situation right there. The Sherman Antitrust Act was based on the constitutional power of Congress to regulate interstate commerce. And this kind of reminds me, family, right here, the power of Congress to regulate interstate commerce about the Dred Scott case. And one of the premises of that is that the slaves actually belonged to be regulated by the House of Congress or the congressman. And so here the House again have the power to regulate business, right? And so another thing to keep in mind is that military science, shouts out to Alton Maddox, peace and love, Alton Maddox and Amos Wilson, Ashe, to those great master teachers. They often say, or they have said, that business and the art of war, the art of military science are integrated. In most cultures, in most nations, the art and military science is integrated with business, meaning that the way you do business, a lot of the principles incorporated are principles of military science. So that's something to keep in mind as we look here, that how Congress has the power to determine how commerce is operated. And so that's another reason why many people talk about the power of the vote, the power of getting someone in the seats of congressmen, because it's not just about lives, but the main thing is about how cash flow throughout the states. But family, do understand, right, also that the voting power is not your only power. Your voting power is not your only power. I would say even that your voting power is not your greatest power. Asiatic man, black woman, your greatest power is your economics at this point within this system. As a defeated people, as a defeated culture, a defeated race, and white of many of our histories, your way back in understanding your way to balance a lot of the injustices that we have to deal with simply because we don't own anything, is through organizing the power of your dollar, right? Your dollar is actually more powerful than your vote, right? And I'll say to Amos Wilson again, that is one of his philosophies. So let's look at what is a trust, right? What is a trust? What is a trust? It says here, a trust is traditionally used for minimizing estate taxes and can offer other benefits as part of a well-crafted estate plan. A trust is a fiduciary arrangement, meaning dealing with monies, right, in some way, or properties or assets, that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. Trust can be arranged in many ways and can specify exactly how and when the assets pass to the beneficiary. Now, this is deep, family, because you're talking about group economics here when you're talking about trust. You're really talking about, in many instances, about group economics and trust. So antitrust is anti-group movements, right? So keep that in mind when you hear these words, antitrust. Let's go a little bit, because these are some things, even though they may be used to against the welfare of African American Americans, the Moors, should I say? Let me get my plug back in. Forgive me, family. There's some things that if we wake up, we can use some or attempt to use some of these same tools. There's nothing wrong with trying, isn't that right, family? It says here, since trusts usually avoid probate, what you say? Your beneficiaries may gain access to these assets more quickly than they might to assets that are transferred using a will. I could say, family, as an investigator, as a private investigator as well, and just my career in law enforcement, that many times I have seen where families are tied up in probate, right? Even with wills. But this is saying that a trust, if you have a trust and put your assets in a trust, that for your family members, they won't have to go through all the problems of probate. I find that interesting. That is something I did not know prior to looking this stuff up. So there's a program around that. Can we get some of our family members to teach our people how to? I'm sure they're out there. If you are on here and you're watching, put something in the comments if you're teaching our people how to create trust. And I think I have a brother who knows how to do that. He's talked about that many times. But family, sometimes when you're talking to us, we don't know what you're saying. And then we ask what you're saying and you tell us you explaining something else than what we actually asking. You know, we gonna get it together though. We gonna get it together. But let's go. It says additionally, if it is a irrevocable trust, it may not be considered part of the taxable estate. So fewer taxes may be due upon your death. Assets in trust may also be able to pass outside of probate, saving time, court fees, and potentially reducing estate taxes as well. Other benefits of trust include control of your wealth, protection of your legacy, privacy, and probate. Because I believe, in some instances, on a trust, you don't even know, it could be protected as to who are the beneficiaries of the trust. You know, I'm telling you, family, it's a lot to web ourselves out of this struggle or this strangle of this complex system of economic injustice, aka racism, aka white supremacy. And I say that in a political sense, not in the individual sense, you know. And I feel like I shouldn't really have to make, clarification as to what I'm talking about. The simple reason that I have to clarify when I speak of these terms is a sign of the power, right, that surround our political and social worldviews. Let me see. Frazier, Frazier Bay. Let me see if he gonna come on here. Islam, Frazier Bay. If you could tap in, man. I'm putting you on the spot, brother. I'm putting you on the spot. I don't have long anyway. Let's see. We'll see if he tap in, family. But Islam, peace of love to Frazier Bay, my homie. All right, so where are we? We are talking about the Sherman Antitrust Act. He talk about we have to plan more. More, you already planned. You already planned up, man. We gotta push the go button. All right. It says here a trust was arranged. It's talking about the Sherman Act. Let's see what the Sherman Antitrust Act, forgive me, the Sherman Antitrust Act was about. It says here, a trust was arranged by which stockholders in several companies transferred their shares to a single set of trustees. Wow. In exchange, the stockholders received a certificate entitling them to a specific share of the consolidated earnings of the jointly managed companies. The trust came to dominate a number of major industries, destroying competition. For example, on January 2nd, 1882, the Standard Oil Trust was formed. Attorney Samuel Dodd of Standard Oil First had the idea of a trust. A board of trustees was set up and all the Standard properties were placed in its hands. Every stockholder received 20 trust certificates for each share of the Standard Oil stock. All the profits of the component companies were sent to the 9 trustees, who determined the dividends. The 9 trustees elected the directors and officers of all the component companies. This allowed the Standard Oil to function as a monopoly since the 9 trustees ran all the component companies. Family, antitrust law. Why haven't we seen this angle, by our talented 10th of our people, of our Asiatic brothers? We may have, if there's some cases out there, please let me know. Remember they had the movement, I think it was the 1%ers, the 99%ers against the 1%ers or something like that. Why wasn't that movement about antitrust law? It appears, just candidly somewhat talking here, that the antitrust law is really a law that is kind of mobbish. It's a mechanism or a construction for the top elite. For those 1 to 5%ers that we can go back and forth and check each other, that we make sure that, we keep the pie among us. The pie small, but it still need to be a pie. But I think that as a people, especially American Africans, the Moors, I think that these are some things that possibly we can look into maybe to find some remedy in many of even the small mom and pop stores that have closed across our nation due to your Walmarts, due to your CVS's moving in, antitrust laws. You know what I'm saying? Due to a lot of businesses that were taking place of. And so when you have these big companies coming in and swooping in these even the rural areas, in my opinion, family, these are antitrust laws because they have positioned themselves where they are not allowing competition. And I don't call competition creating competition where a big company comes in, swoop up all the contracts, and then give a percentage of their contracts to contract out to so-called black folks. That's still a monopoly. It's still a control of the major pie, you know? So we're going to close here. I wanted to remember I showed you earlier about this term. Sorry about that. In the Antitrust Law or Acts, where it says here, rule of reasoning, right? And I think that's very important because this establishes a context. This establishes a context, and therefore, if you have a context, you cannot begin to go and apply that true justice if when they're talking about antitrust and when they have defined monopoly one way and you have defined monopoly another way. And so you got to know what you're dealing with. And so let's see what we're dealing with here, family. Let's look at it. Rule of reasoning. And I'm coming out of the Black's Law Dictionary, 6th edition. Here it is. Rule of reasoning. You may want to take a camera shot of this one because this could be used as a backdrop to some other things too, I believe. Okay, it says rule of reasoning. Test for determining whether alleged acts violated Statute 1 of the Sherman Antitrust Act, which declares conspiracies in restraint of trade to be illegal. Fact finder must weigh all circumstances of the case to decide whether practice unreasonably restrains competition. And so these words here, how is unreasonably defined? How is practice defined? How is restraints defined? If I say it's unreasonable restraints that mom and pop stores had to close down because CVS moved in around the corner, with the help of the black media providing them statistics like we in some later demonstrations demonstrated, they may find that is reasonable because the black news media profited off of it and therefore is not a monopoly because some blacks got some checks. Jay-Z, because some blacks got some checks. You know what I mean? Let me stop. I'm starting to wild out a little bit here. Let me stop. All right. So it says here, let's just finish it. Let me get back on track here. All right. And we're going to close out for real. And the test requires that plaintiffs show anti-competitive effects. The test requires that the plaintiff show anti-competitive effects. Can we do that with the NFL? Can we show that the NFL, can we show that the college football divisions show anti-competitiveness effects against the HBCUs, which every time I know here with FAMU, right? Shouts out to Coach Billy Joe. Every time FAMU has a very successful season, and that coach began to try to take the HBCU, the MEAC, and try to take FAMU out of the MEAC and go to the next division, Division II, that coach is fired. I noticed the same thing with Bethune-Cookman. Every time they have a very successful run, a couple of runs, and that coach decides he wants to go to the Division II, that coach is fired. Are we dealing with antitrust laws concerning HBCUs? I need the Federal Trade Commission to holler at your boy. No, holler. I ain't gotta clarify everything. I'm having fun. All right. Or actually harm to competition. So let's read that again. The test requires that plaintiffs show anti-competitive effects or actual harm to competition, and not whether the practice were unfair or torturous. And it has Richmond Hoffman. These are some cases that you can look up to further your studies. Oh, let's read here. Under the rule of reason, in antitrust law, the legality of restraints on trade is determined by weighing all the factors of the case, such as the history. Whoa, wait now. Let's not bring up history now. We got some on that. Of the restraints, the evil believed to exist. Oh man, now they put that believe in there. Why they couldn't just say the evil that exists? The reason for adopting the particular remedy and the purpose or end sought to be attained. And they got U.S. versus National Social or Professional Engineers. That'll probably be an interesting case to look at. So family, there you have it. Just some little insight about antitrust law, as we may hear more about the antitrust law dealing with Facebook. It'll be interesting to see how that takes its course. But when you begin to have conversations with your fellow U.S. citizens, bring up a little bit about antitrust law when the topic is appropriate, because I truly believe that antitrust laws, right, have been committed certainly against African American businesses. So with that being said, I hope that you have a blessed day. Make the best of what you have. If you have a lemon, it's okay. Make a lemonade.